Hi everybody, my name's Carol Saunders and I'm the Union Relationship Manager at Gordon Legal. I thought today would be a good idea to introduce you to Fiona Rothville, who's one of our employment law lawyers, to talk through the new JobKeeper scheme with the focus of giving you some information about what your rights are as employees, especially if you've got an employer who's directing you to do certain things. It's really important that at the end of this process, if you've got any questions, contact your union. And if the union need to make a referral through to us, then they'll do that. So what are the basics of the scheme, Fiona?
So very simply, if employers or businesses have suffered downturn due to the coronavirus, they're entitled to apply for the JobKeeper program, and that provides a $1,500 before tax payment to employees to help subsidise the wages. So the money will come from the ATO, pass through the employer and be distributed to employees who fit the eligibility criteria. Registrations for the scheme have opened. They've been rather overwhelmed, and employers will be able to formally enrol in the program from the 20th of April. Employers will have to notify the ATO that they're eligible as employers, and also that employees are eligible and nominate which ones. The employers will also have to tell those employees that they're intending them to be nominated for the scheme. So employees should know if that's something that their employer is going to do. And of course, some employees will be concerned if the employer is not going to go down this path, and that's when they can perhaps be alerted to it and talk to their union about it.
And that $1,500 figure, so what if employees earn more than that a fortnight?
Employees who work and earn more than $1,500, they'll continue to be paid their regular ordinary salary. So if, say, they were earning $1,700 a fortnight, the $1,500 would be a wage subsidy towards that wage, and then the employer would have to top them up with the remaining $200 or so. And that's if they're working their ordinary hours. If they're earning less than the $1,500 or the $1,500 exactly, then they have to get the $1,500. So some people, such as part-timers or casuals that are eligible for the scheme, may in fact get a small bump because they have to be paid that minimum $1,500 payment.
And Fiona, just in terms of employers who start making some decisions about stand down, what about employees who are stood down or have their hours reduced? Can employers actually do that?
Yeah, so that's probably one of the most radical aspects of the scheme, which is that while employers and employees are subject to this scheme, so they've enrolled, they've been accepted, they're getting this $1,500 payment from the government, there's a whole range of different directions that an employer can give to employees. That includes reducing their days or hours of work, including to none. So this type of stand down, I need to just point out, it's slightly different from the normal Fair Work Act stand down, or a stand down that might exist in an employment contract or an employment agreement, where there's a stoppage of work for which the employer can't be held responsible. This is very different. This is called a JobKeeper stand down, and it's where this direction can be issued by the employer who's under the scheme. In terms of your pay, if your hours are reduced to none, then you'll just get the $1,500 before tax minimum payment. Otherwise, what can be done is that you might be directed to work a reduced number of hours, which means that your hours are reduced to match the $1,500 payment. What's interesting about the scheme is that you've still got to be paid your ordinary hourly rate. So that means that you have to have your hours reduced so they're not getting more for nothing, essentially. So you might, for example, do only 25 hours a week to get to the $1,500 payment. And that way the employer still only has to match the $1,500 payment, but they're still getting some hours of work out of you. And it's quite important that employees realise that it's the $1,500 before tax payment. There's no right of an employer to take some sort of administration fee or deduction from it. It's an offence if they do.
And when can this be done by an employer?
So an employer can only make a direction as long as they fulfil certain requirements under the Act. So that includes that the employee cannot be usefully employed on their normal days or hours because of the changes attributable to the coronavirus pandemic or because of government initiatives as a result of the pandemic. And the other thing is that the direction has to be safe, having regard to the pandemic. So, for example, if you can't be employed usually or in your normal days or your normal hours because perhaps the business has suffered a drop in patronage or a drop in orders or a drop in just general business, then that might be a basis. And the other thing might be if where you're working's been shut down, perhaps because of a government direction that you can no longer provide that business or provide that services. So that's a sort of basis on which they can do it. If employees are concerned about it, what I'd recommend is they just check and find out, well, can I not be usefully employed to work on the days or hours? Why not? What is it about the pandemic that's changed our business? Now, in this climate, obviously, there's going to be a really broad scope for that. But if there is concerns that maybe, an employer's taking the mickey about the fact that there has been a downturn to, as a sort of a ruse to cut hours, then try and pin them down on what the exact reasons are. And then perhaps that opens them up for a challenge if they can't give you answers, or if it's a dud answer that really doesn't make any sense.
What else can an employer do? Can they instruct you to work different duties or go to different locations? What powers do they have there?
For the life of this JobKeeper scheme, there is these powers. So this is a 6-month scheme. So from now until end of September, the employer is authorised to give what's called a JobKeeper enabling direction. And that can include a direction about the sort of duties to be performed by an employee, which might be different, and also the location of an employee's work. And that could be including to a direction to work from home. The duties have to be within an employee's skill set, competency, within their qualifications or licensing. So again, you can't just say, well, I need you to do some sort of electrical work or plumbing work if you're not licensed to do that. But it's got to be within their skill set. And the other thing is with the location, it has to be suitable for the employer's duties. So you can't just say to someone, set up your home like a proper site if that's not safe or suitable. And also, if the place that they've been redirected to is not the home, then the distance has to be reasonable in all the circumstances. So yes, you can be asked to do different duties in different locations, but that's subject to certain limitations. The other thing is that an employer can ask employees to do different days or times of work. Now, that needs to be agreed to by the employee, but they can't reasonably refuse that request.
In regards to rights as an employee, what are my rights in regards to the stand down change of work location?
So with any directions about stand down, your hours of work, changing your duties, changing your work location, any of these directions has to be reasonable in all the circumstances. And it also has to be necessary to save jobs. So again, these are elements that have to be met. You also have to be given 3 days notice in writing of those changes. You can agree to less notice if you wish. And you also need to be consulted, or your union has to be consulted about those directions as well. So that's a sort of an important safeguard to remember. The other things that are protecting you are obviously that things have to be within your skill set and they have to be safe for you to perform. One of the types of unreasonableness sort of directions that might be also thought about is, for example, if you've got caring responsibilities or other responsibilities to the family, that may be another sort of basis or area to explore in terms of whether or not a direction is reasonable or not. The other thing that's a protection, any of these directions can be revoked by the employer or a new direction can be issued. And the other thing is that any of these directions will cease to have effect on the 28th of September, which is when the scheme comes to an end. And finally, if there are issues and concerns, absolutely talk to your union about them, because there are opportunities for any of these concerns to be raised and heard as a dispute in the Fair Work Commission, which obviously union members will be familiar with some of those processes. But the Fair Work Commission has the power to set aside certain directions or amend directions so that they meet these conditions.
So if you've been stood down, do you have any rights to do any other work or other training?
If you have had your hours reduced or even reduced to none, then you can ask to perform a second job or undertake professional development or training activities while you're not working. You put in the request to your employer and your employer has to consider the request and can't unreasonably refuse.
Can I be forced to take my annual leave? And another question following from that is, can I take annual leave at half pay?
Under the JobKeeper scheme, so remember within this bubble of the scheme, you can be asked by your employer to agree to take some annual leave as long as you're not going to be reduced to a balance of less than 2 weeks. You have to consider the request and you can only refuse if you have reasonable grounds to do so. Again, depending on your circumstances, talk to your union, get some advice if there are issues there, but otherwise it will be a direction that they can give you. Your annual leave, though, will be paid at your usual rate of pay. The other thing is that you can agree with your employer to take twice the period of annual leave at half the rate. This is by mutual agreement, so it's something that you'll have to request and get agreement with your employer. In the situations where you are on your annual leave, the employer will continue to get the $1,500 wage subsidy payment towards your annual leave pay. So that's important to know, and you should obviously still be getting that flowing through. Outside of the JobKeeper bubble, that's where you need to get some advice about your particular circumstances if you're not part of this scheme, because of course, the rights of an employer to force you to take annual leave will depend on your contract, your enterprise agreement, your award, things like that. So it's quite specific to your situation.
Bea, thank you for that. I think you've clarified, what can be quite a complex and confusing situation. Thank you so much for those answers.
You're welcome. Sorry there's so much detail, but there is a lot of detail in this scheme, unfortunately. We will put some more information up on our website at gordonlegal.com.au. There's a whole suite of materials there for people on commercial issues, family issues, things like that that are affected by coronavirus. But we'll definitely have quite a bit up there about JobKeeper scheme and some of these directions that can apply, as well as the scheme more broadly. So hopefully it helps union members.
Thanks very much, Fiona. And anyone listening and watching, any inquiries, please feel free to contact the union to get a referral through to us, and I'll make contact with you to see if we can help you out.